Welcome to People's Law School, sponsored by the McCracken County Bar Association. And for this segment, we're going to talk about personal injury litigation. In other words, filing personal injury lawsuits where a person has been injured and is claiming another is negligent and is seeking money damages. My name is Ogden. I'm a lawyer here in Paducah, and I want to introduce my guest here today, just my cohort. How's that? Mr. Grumley, if you would introduce yourself and give us a little background concerning your qualifications to practice law.
Sure. My name is Miller Grumley. I'm an associate at Bradley & Freed here in Paducah. I practice primarily in the area of personal injury law, but more so in cases involving medical or other types of professional negligence. A lot of times people refer to it as malpractice, but we also handle various other different types of civil actions with personal injuries, motor vehicle accidents. We work in defense of railroads and other medical providers. I graduated from college at Wake Forest University in 2001, went to the University of Kentucky College of Law, where I graduated in 2004, and I've been practicing in Paducah since that time.
All right, and if it's all right with you, I'm going to call you Miller, unless we get into it, and I want you to call me Lynn. This is an informal thing, even though we're on television. As I said, I practice here in Paducah. My practice primarily includes personal injury litigation for the plaintiff, criminal defense, and also some civil rights work for the plaintiff in federal court. It can also be in state court, primarily suits against jails, police officers, and penitentiaries and their employees. I went to the University of Virginia for my undergraduate, graduated from there in 1971, I think, and then I went to law school at the University of Louisville, of course in Louisville, Kentucky, and graduated there, I think, in 1974. So I've been licensed to practice since about October of 1974, which makes me the old guy here, and you're the young guy. So I don't remember much about law school, but over the years, I guess, making a lot of mistakes, hopefully I've learned a little bit. And so I'm going to rely on you for the more updated viewpoint. And today I'm going to talk probably more about the plaintiff's side of personal injury cases and let you, if it's all right, talk more about the defendant's side, the person being sued, although your firm certainly does both sides. What is a personal injury lawsuit? I kind of gave the audience a little bit of an idea a few minutes ago, but if you could sort of define that for them.
Sure. A personal injury lawsuit, again, is where somebody has been injured through conduct by another person. I think there are two broad types of personal injuries, and they're known as torts. One is an intentional tort, where someone makes an intentional act, such as if I struck you in the face, that would be a tort of battery. And that involves this conscious element of intent to cause a certain result. The other type is negligence, and that's what you hear probably a lot more about, and that involves various elements where someone failed to adhere or comply with some sort of standard of care that they owed to the other person.
All right, and tort is spelled T-O-R-T, correct?
That's right.
So we're not talking about a tort like something that someone might make for a wedding reception. The word negligence, you kind of described that a little bit. Are there certain duties that usually people have under certain circumstances, and if they violate or breach or don't comply with those duties, that can be negligence?
Sure. I mean, depending on the particular circumstances, that are involved there, but there's a broad variety of duties that one owes. For example, the broadest conception of it is that you have a duty to use ordinary care in whatever activity that you're participating in. So if you're a physician, you have to use ordinary care in your treatment of the patient, for example. And again, that can be a broad range of different types of conduct, but you have to conform it generally to the ordinary care of a reasonably prudent individual.
All right, so when we came into the studio today, we had a right, did we not, to expect that the floor would be in a reasonably safe condition for us to walk on, and if Mr. Butler, Tom Butler, had spilled some coffee and hadn't cleaned it up, and we came in and slipped on it and fell and hurt ourselves, then we might have a cause of action or a lawsuit against Mr. Butler, and maybe not against the college or the university here because of the fact that they might have sovereign immunity, which we won't go into. But anyway, that would be the duty that he would have. Is that correct?
That's right. And a lot of it depends on the circumstances or the classification that a particular person owes when they walk onto somebody else's premises. For example, you can have an invitee, or you can have a licensee, or a trespasser. Typically, when you're talking about here a slip and fall type circumstance, the most ordinary type of suit is stems from somebody slipping and falling in another's business, you know, any sort of business, and that typically would make one a business invitee, and there are certain duties that are owed to that person.
All right, so when you're using terms like that, would I be correct that depending upon what a person's status is, if they're involved, say, in a slip and fall case, the person they're suing, the defendant, may have a higher duty or higher standard of care. For instance, you said a business invitee, and then a licensee, and then a trespasser. So there might be a higher standard or a higher duty on the business invitee, like going into CVS Pharmacy, versus if I was just to, say, park in CVS Pharmacy's parking lot and walk across the street to Walgreens.
Right, and again, it's how you're classified. Now, these classifications aren't rigid. There's some fluidity between them. But for example, if I trespass into your lawn and somehow injure myself, that doesn't necessarily mean that I do or don't have a right of action against you. That all depends on what your duty was. For, again, an example of a trespasser, your duty is not to cause any sort of willful or wanton injury towards me. You have no duty to warn of any hazard or to take any remedial actions, but once my presence is known to you on the premises, you can't do anything that would hurt me. That changes, of course, as you go up the classification scale from a licensee to an invitee. And typically, again, we think of, in slip and fall cases, a business invitee at the drugstore or something else. And I think, interestingly, there's been a recent change in the law as to various elements of a claim by an invitee on a premises.
All right, and trespasser would be, say, if I had a swimming pool, which I don't, and it had a fence around it, and you climbed over the fence and you slipped on a bad place in the concrete, or fell on because of a bad place in the concrete and hurt yourself, you'd be a trespasser, right?
That's right.
And because I had the fence around it, I might not owe you any duty, and I might not be liable to you for your injuries and damages.
That's also correct.
Well, let's shift gears just a little bit and generally talk about something known as the statute of limitations as it relates to bringing a lawsuit for some type of injury. What is a statute of limitations in general, Miller?
Well, a statute of limitation is a period of time prescribed by the legislature or some other statute in which you have to bring your lawsuit in order to recover. And it's real important to point out that if a potential claimant does not bring the action within that specific period, they've lost their right to pursue any claim for recovery.
All right, they'd be forever barred from bringing the action, bringing the lawsuit, and recovering any money, even if they had 1,000 witnesses and could prove beyond all doubt that the other party was negligent, and as a result of that negligence, the person was injured. Is that right?
That's right, and also it should be pointed out, you said they have 1,000 witnesses. You're correct. It doesn't matter how good the case may be or how severe the injury might be, as long as the case is brought outside of the statutory limitations period, then it is forever barred and it can't be pursued.
And how would you caution those in the audience concerning statute of limitations so that they don't end up at the lawyer's office and the lawyer says, "Oh, I'm sorry, you're barred from bringing this claim by the statute of limitation"?
Right. Again, with the how strict a statute of limitation is in regards to your ability to bring a lawsuit, it's real important that once you first think that you've been injured or might have a claim against another person, it's real important to go directly to a lawyer and seek some sort of legal advice. You don't want to sit around and what the cases refer to as squander your rights to bring the lawsuit. You need to seek pretty quickly some legal advice.
All right, just as a sort of measurement, I guess, what is normally or usually in Kentucky, and that's what we're going to be talking about, is Kentucky law here, the shortest statute of limitation on personal injury cases? Right.
In most personal injury or tort cases, there's a Kentucky statute that provides for a 1-year statute of limitations. You got to be careful because there can be some shorter ones depending on the circumstance or depending on the potential defendant in that case. But generally, a tort action must be brought within 1 year of the date your cause of action accrued.
All right, and that'd be applicable, what, to slip and fall cases?
Sure, it would be applicable to a slip and fall case. It would be applicable to a medical malpractice case. And a variety of different ones like that.
Now there is a difference sometimes on automobile accident injury cases, is that correct?
Right, there is a difference and that's because there's a particular statutory scheme that applies to litigation of motor vehicle accidents and that provides a different statutory limitations period in which a claim has to be brought.
So without going into too much detail on that, we would just say that if no fault, and we're not going to talk about no fault today, we've talked about it in past times, past years, but if what we call no fault was paid for medical or wage loss or both by your own insurance carrier or company, then you would have a 2-year statute of limitation. But let's say, for instance, you were uninsured. And there was no fault to be paid, unless you were like a pedestrian, it'd be a different situation. But you're an uninsured driver, and somebody else runs into you and you're hurt. Then the statute of limitation would be 1 year, wouldn't it?
That's right.
There's one other thing, so that we don't mislead anybody, that I was thinking about, since we had mentioned some slip and fall. In fact, we mentioned that a lot so far. Maybe we can get off of that subject. I'll try. But there are some hidden statutes, I might call them, sort of not known that well. For instance, if I was to fall on a city sidewalk and wanted to sue the city because the sidewalk was all uneven or had a big hole in it, then I would have to give a notice under the law. Is that also correct?
That is correct, and there'll be a certain time period within that you have to provide the notice to the city.
And I believe the statute says 90 days from the date of the injury, and so while we might not call that a specific statute of limitation. It's something that has to be done, and then the lawsuit filed within a year after the accident, or else if you don't give that notice, you're not going to be able to recover. Is that the normal result or consequence?
Typically it is, and again, that's the importance of acting quickly. Once you believe that you might have a potential claim, 90 days is 3 months. That's significantly less than a year. And if you sit around and don't take quick action, then you could lose your right.
Now, if I'm laying in the hospital for a week after I'm injured, I don't really have to worry too much about the statute of limitation during that week, do I?
Well, you do. There are some types of situations in which the statute of limitations period is suspended from running. For example, if I was less than 18, the statute of limitations would be told, is how they say it, until I reached 18 years of age. Or if I had some sort of if I had some sort of mental incapacity, or if I was in a coma, various different things can suspend it. But typically, if it's not something particularly extreme, you still want to try to bring your action as quickly as possible to avoid any sort of complication or problem, or even some sort of argument that the statute of limitations has expired.
I wouldn't need to crawl out of my sick bed 3 days after the accident and get down to the lawyer's office. I'm going to have more time than that. But if I'm getting on, if it's a slip and fall case involving a city sidewalk or just about anything else, you know, a month or two goes by, I better be looking at talking to a lawyer and finding out, at least over the telephone, if not in person, what the statute of limitation is that's applicable to my case. That'd be fair?
Yeah, that's right.
Now, once I get to the lawyer and we get the fee arrangement worked out, and by the way, how do lawyers seem to more often than not charge if they're representing the plaintiff?
Well, typically there are arrangements known as contingency fees. When the amount that's owed to the lawyer for services is a certain percentage of what ultimately will be recovered. That's not the exclusive type of fee arrangement. There can be situations where you pay your attorney by the hour, but oftentimes for a plaintiff it's a contingency arrangement.
All right. Now, I don't want to get into your office's fees, but say just for a sort of a regular, whatever it might be, a regular automobile accident or motor vehicle accident case, the plaintiff, the person that's going to be suing because they were injured, what are they looking at as a contingency fee among most lawyers practicing today?
I think very frequently you'll find that the average fee, or the most often contingency arraignment would call for a 1/3 percentage that would be paid at the end of the case to the plaintiff's lawyer. Now, these fees can range depending on the complexity of the case or the expenses that would have to be incurred in preparing the case adequately. So you could expect anywhere from as low as 25% to maybe as high as 40 or even more if it's a particularly complex case. But I think the average would be around 1/3.
And then if something goes awry and the lawyer for the plaintiff doesn't recover, but does decide to appeal, and then after the appeal is over, case comes back down, gets tried, and there's a recovery, or settled, and there's a recovery, is there a usual increase in the percentage that's charged under your contingency fee contract?
Well, again, it just depends on the particular contract or the particular agreement reached between the client and the attorney. Sometimes there might be, but other times I would say certainly not.
All right. In my instance, I don't know how all other lawyers do it, but if I'm handling a car accident, it's usually 33 1/3% before appeal, recovery after an appeal. I'm talking about to the Kentucky Court of Appeals or Supreme Court of Kentucky, goes up to 40% because I have to do a whole lot more work, and that is the reason for or what justifies that kind of increase in percentage. Let's pardon me. Let's talk just a moment about once you're got the fee squared away and a representation contract in place. And by the way, should the client expect a written contract with the lawyer?
Most certainly, lawyers are required to state the terms of the fee agreement in writing. That's an ethical requirement, so you should expect to be presented at some point with a written contract.
Yeah, that's so everybody has an understanding, and like you said, that's an ethical requirement in Kentucky. So you can't overlook that as a lawyer, can you?
No, you can't. And it is important that everybody has the right idea of and the appropriate understanding of what the arrangement is between the attorney and the client, and that way there are no incorrect assumptions made as to the scope of the representation or to the amount of fees that would be due at the end.
Now, if a lawyer accepts a client and the client accepts a lawyer and we got everything going, sometimes a lawyer may be able to settle the case or the claim before having to file a lawsuit. Is that right?
That is right.
And in the instance where that doesn't happen and there needs to be a lawsuit filed, we have something that comes up in the law that we term jurisdiction, something that needs to be considered by the lawyer. What is jurisdiction?
Broadly, jurisdiction is the power of the court to either entertain cases on a certain subject matter or the power of the court to hear a case over a certain person. And those two broad categories of jurisdiction are called subject matter jurisdiction and personal jurisdiction. Subject matter jurisdiction most frequently arises when you're dealing with federal courts for various reasons. That's because a federal court is of some limited jurisdiction, where state courts are probably more appropriately referred to as having a general jurisdiction over most state claims.
All right. Now, without getting into the federal court jurisdiction right now, since probably more, well, I'll just ask you, would I be correct that more lawsuits locally here are filed in the circuit court over at the McCracken County Courthouse than in the federal court at 5th and Broadway?
That's right. And again, that stems partially from the limited nature of a federal court's jurisdiction. But routinely cases would be filed in the McCracken Circuit Court if you're in McCracken County.
Does the monetary, in other words, the amount or the sum of money that is being sued for or claimed have anything to do with jurisdiction?
Sure, it does affect which court you can file your claim in.
Let's take an example. Let's say that I nicked my fingernail in that automobile accident, and I'm going to sue for $1,500. Can I file suit in the McCracken Circuit Court and have my case assigned to either Judge Jeff Hines or Judge Craig Clymer?
No, you wouldn't be able to, because the amount in controversy wouldn't be high enough to bring that action in the circuit court. It'd have to be brought in district court.
Do you recall, and we haven't rehearsed this, but so I don't want to put you on the spot. A lot of things I have to look up, and I imagine you do too. That's the way lawyers have to do it. But do you remember the jurisdictional amount necessary to bring a lawsuit for personal injury in the circuit court?
I believe it's $4,000.
You're right. And let's look at another aspect of jurisdiction. Or it might be called something else. But let's say that I'm in a motor vehicle accident over in Marshall County near Benton. And I'm from Paducah, and the person that hit me, excuse me, Marshall County, but is from Benton. And I'm claiming that the person from Benton was at fault, was negligent, and caused my injury. Where can I file that lawsuit?
Well,
I gave you a tough one too.
Well, it depends on what Mr. Ogden's talking about is the venue of the case. Where is an appropriate venue or court to hear the action? And there are a variety of statutes depending on the particular type of action. But the general venue statute would provide that you can bring the action in the county where the accident occurred or the county where the defendant resides.
All right, so in that instance, in all likelihood, as the Paducah or McCracken County plaintiff, I'm likely to have to file that lawsuit over in Marshall County.
That's right. There can be, say for example, the vehicle that was being driven by the person that you say ran into you was owned by a corporation. There'd be a different set of venue provisions that would control that. They're not necessarily very different, but they are different and can have some implications under certain circumstances.
All right, and we don't just guess at these matters about jurisdiction or venue, which, you know, we kind of talked about them as, or I did, as if they're kind of the same, and they're not. But we don't just guess about those things. They're actually statutes or laws that we can look at that tell us when a venue is in a certain place and when jurisdiction is in a certain place or not. Is that correct?
That is right. There's, again, for venue, there's a list of, I can't tell you how many statutes. There's several. And again, even for the statute of limitations, going back to that, there's quite a few statutes that provide different periods under different types of cases or different circumstances.
All right, we didn't get too far because we only had 30 minutes, but we're about out of time. And is there anything that you might say in a sentence or two that would tell a person a good way to pick a lawyer to handle this type of case?
Well, what you want to look for is someone who has some experience in the particular area of law that your claim might be. For example, I practice mostly defense cases, so I wouldn't be a necessarily good choice for a workers' compensation claim.
All right. Well, Mr. Butler is going like this at me, which means we've got to wind it up. I've enjoyed talking with you about this subject today, and thank you all for tuning in and watching. And again, we've been talking about personal injury litigation. Have a good day.